Now is the time set for oral argument in cause number 1CACV 18-0784, John Doe, Plaintiff Appellant versus Arizona Board of Regents, Defendant Appellees. For everybody's information, and it probably won't come as a surprise to you, these proceedings are being audio and video recorded and live streamed. So in the absence of any problems, which could happen, but we hope won't, you can critique yourself in a couple of weeks. Counsel, each side will be entitled to 20 minutes, and we would ask that you respect the time period. The timer located on the podium will let you know how much time you have left. And for the appellant, if you wish to reserve any portion of your 20 minutes for rebuttal, let us know. We can try and help you avoid using up all of your time, but ultimately your reserving of rebuttal time will be up to you. We've reviewed the briefs and conferenced the case this morning, so we are well aware of the facts and issues attendant to this argument, and we tell you that so you can keep that in mind when you decide how you are going to use your own time. Counsel, when you come to the podium, I would ask that you state your name and who you represent so that we've got the complete record. And with that, the appellant may begin.
My name is Leonard Aragon. I'm from Hoggins, Berman, Sobel, Shapiro, and I represent the appellant, John Doe. May it please the court, good morning. I'd like to begin by addressing the incapacitation issue. And specifically, I want to explain why I'm not asking this court to reweigh evidence. Generally, in a case like this, you're going to get two narratives, right? I think the Doe v. Baum case is a very good example. In that case, there was similar allegations. All of the males from a certain fraternity had one version of the stories, and all the females from a sorority had a different version of events. And then the court had to address that version, address those competing versions to come up with a decision. And to ask you to reweigh that would be improper at this stage in the case. The difference here is you don't have to look at my client's version of the case. You can look at the complainant's, Jane Rowe's version of the complaints. And the reason you can do that is she admitted in her version of the facts at the essential elements of the defense to this case. So let me explain. The question in this case is, was she incapacitated? At least one of the questions. And to answer that question, you ask whether or not she can make rational and informed decisions and judgments. There are 4 admissions that she makes. There are 4 admissions that she states. This is her version of the testimony. This isn't my client's version of the testimony. This is her version of the testimony that comes from her statements to the police. This is her version of her testimony that comes from her statements to the ASU administrator. This is her version of the story that she admits at the hearing. And let me give you the 4 examples. The first one, she's being videotaped. The person who videotaped her is not my client. That person got in trouble criminally. My client didn't give him permission to make that videotape. He's taking a videotape while the incident is happening. And she goes, "What are you doing? Are you taking a video of me?" And he says, "No, I'm not." And she says, "No, you're lying, stop." And he stops. That's a rational, informed decision. She didn't want to be videotaped while she's naked having sex with 2 other men. A rational, informed decision based on her version of the facts, her statements to the police immediately after the incident. If that's true, that's an admission. You don't have to go to circumstantial evidence. That's an admission by her. Second, the sex started hurting. What did she do? She made the rational, informed decision that she wanted the sex to stop. That is an admission. That's based on her facts. She admitted that at the hearing. She admitted that to the ASU investigator. She admitted that to the police officer. This is a very important one. My client asked if his friend could finish, if he could ejaculate. And she said, no, he cannot. And then later she tells the police, I know they didn't ejaculate because I didn't let them. What does that tell us? That tells us that she has the wherewithal, the mental capacity to know whether or not this young man has ejaculated, to know whether or not he's about to ejaculate, and to control that situation. Those are rational, informed decisions. Those are manifestations of capacity. Those are admissions. Those are her versions of the facts. And then the fourth one is that she was a full participant through this process. She said, and I apologize for the language, but it's the language of the case, she was giving blowjobs during the intercourse, giving blowjobs.
That was a comment she made on that recorded call, right?
On the recorded call with the police officer, the day after the incident,
Yeah.
she said she was giving blowjobs, yes.
She also says that she was coached, or at least, although she didn't say they provided a script, she was told what to say. So why would we count that one the same as some of the other statements?
Well, you're not going to lie about that part. That's not part of the scripting. Giving blowjobs isn't something that's going to be scripted by the police officers. And we asked her, well, what did he say and what did he do? And she didn't really tell. She couldn't tell us what the script was. And we could talk a little bit later on about the due process problems here. That script was never obtained. Those notes were never obtained by ASU, and you don't have discovery rights here. So
I just want to make sure that that was the context of that statement. And okay.
No, I appreciate
go on.
that, Judge Johnson. But the context is she said that she was giving blowjob, but she also said, I was participating in the sex for 20 minutes and described it to the police officer the next day. And she said she was on all fours, and once again, I apologize for the language, doggy style, which means she was on all fours on her hands and knees. That's not something an incapacitated person can do. We look at the ATIXA standards. ASU says we look at ATIXA standards, and they have a list of things you look for to see if someone's incapacitated. They're passed out. They can't talk. They're almost passed out. They're falling down. They can't communicate with you. None of that occurs.
But ASU's definition, and it's not entirely clear from their guidelines or their handbook, but it talks about incapacitated and then provides either examples or narrowing language. And the ability to make rational, informed decisions is one of them. Would you agree with that?
I believe that is the fundamental question that they ask. Are you able to make rational?
And so what's your evidence or your statement of law to say that that is the same thing as being blackout? It seems like there's a wide gulf between the ability to stand and the ability to make rational, informed decisions.
I agree. So the full statement
then
is
her being able to maintain an all fours position is not necessarily the same as incapacitated.
The definition of incapacity by the university is not a model of clarity. But and I don't have it written down here, but if I believe it specifically, it says physically and mentally unable to make rational and informed judgments and decisions. So the mental ones are the communications that she made. The physical inability to stay awake, to communicate, would illustrate, would allow you to make the inference that she's unable to make informed and rational decisions.
What's the difference, or how do we know what the difference is between merely being impaired and being incapacitated?
And I think that's one of the problems we have here in the standard that Dr. Runn applied. I think you need to separate drunkenness, which is really the evidence that we have here with incapacitation. And ATIXA provides us some of these guidelines. And once again, Doe v. Baum is a good example because the case is very similar here, all the way down to the accuser saying, I don't want to have sex, and then having sex, and then two versions of the stories that are very, very analogous here. But he conflates drunkenness with incapacitation. So all the evidence that he points to shows that she was uninhibited, or she may have changed her mind, or she had memory lapses. When you're incapacitated, according to the standard that ASU uses, the ATIXA standard, you're passed out. You can't communicate. In Doe v. Baum, she had to make vomiting noises to get the attention of someone else. You contrast that, that's what the case is. You contrast that here, where she's telling them, no, you can't ejaculate, no, I don't want to be, well, she didn't say I didn't want to be pregnant, but you can't finish, I want you to stop having sex. These are objective manifestations of capacity. So where exactly can you draw the line? That's difficult. That actually goes into our due process argument, which is the trier of fact, the person who looks at the testimony of our adverse parties, and the witnesses in this case is the person who needs to be able to make that incapacity determination. And the trier of fact, the true trier of fact, the one who saw all the testimony, the one who heard the evidence, the board, they found in favor of my client. They weren't able to find that she was incapacitated. Dr. Run, who looked at the transcript, theoretically, there's no proof of that, or heard the transcript, theoretically, there's no proof of that, found to the contrary and made a credibility decision without looking at the credibility of the witnesses. He didn't have cross-examination.
Then what was the credibility determination, to your estimation, based upon?
On her testimony, how we have all cross-examination.
And you said two on her testimony.
Her credibility determination was based on her testimony and her cross-examination and the evidence as a whole, including my clients.
The board did find force.
The court did find force. The problem with the force finding is that there was no notice of force. We never presented a force defense. There are, I believe, 4 citations to the record where force is mentioned. That's not how you defend a forcible rape case. If this was a forcible rape case, we would have asked more than 4 questions about force. Force was never noticed. In the charging letter, it's not in there. In the sanction letter, it's not in there. In the investigation report, there's no substantive discussion about force. In the hearing notice, there's no mention. The word force isn't used except in the citation to the statute. In the opening and the closing at the presentation at the hearing, there's no mention of force. At the dean of students, we asked her, is force an issue? She says no. The procedures, if you find force is an issue, you don't need to go to incapacitation. It doesn't matter if they're incapacitated.
You mentioned your due process issues on another issue. We can't fathom how the cross-examination actually took place, the cross-examination of complainant. How did that actually take place?
It's an unusual process. The transcript that we submitted to as part of the record says that Mr. Carey did the cross. I did the cross. It's a mistake in the transcript. I asked a question to the chair of the hearing board.
Orally? You'd ask
Orally. Or I would point to my papers. Generally, it was orally. And then he would decide whether or not that question was appropriate.
So you had to write them all out ahead of time?
I did. I had to write them all out ahead of time, and then on the fly, depending on her answers, I was able to ask questions that weren't written down. So,
Go ahead.
oh,
Finish.
okay.
Did
So
you just whisper to him, or what'd you do then?
I whispered them to him, or I would point to a piece of paper and then ask the question. It was very ineffective, but effective ultimately.
What was the basis for his determination of propriety? You said if they were proper, they would go forward if he thought they were proper. I believe that's what you said.
I don't know what his standard was. That was never articulated to me. I don't believe it's in the manuals or anywhere, but it was based on his discretion.
I did not see any case in the transcript or any situation in the transcript where I could discern that you had asked a question and he had refused to ask it. I saw somewhere he asked questions and then the representative of the board objected, and those objections were, I think, sometimes sustained. But does the record show us where you tried to ask a question and he decided it was inappropriate?
There were questions that were asked where they had to be adjusted, if I recall correctly, based on questions that came up in response to an answer that the.
So you tried to ask follow-up and he
I did, and
refused?
we had conversations. I don't recall exactly if they were explicitly rejected, but I doubt those conversations. Well, I know those conversations couldn't make it to the record because we were whispering to the side.
Define the circumstances by which a question was determined to need to be adjusted. That's not language I remember from law school. So help me out here.
I agree, Your Honor. Unfortunately, I don't recall specific questions that I adjusted based on my conversation with the chair, and I don't believe they're in the record.
Or that he adjusted based on?
That.
Yeah, I'm sorry.
Yeah,
That's correct,
okay.
Your Honor.
So you ask a question, if I'm correct, you asked a question, the gentleman with you then adjusted the question if he thought it was better asked or more appropriately asked some other way?
Generally, no. Generally, he would ask verbatim the question that I asked, or he would ask verbatim the question from my sheet, my list of questions.
Where did the adjustment come in?
As I said before, recall conversations regarding certain questions, but I don't recall specific questions that were adjusted.
And they would usually have been follow-ups when you would ask he'd ask the question verbatim, and then she responded, and you tried to follow up on that.
That's correct, Your Honor. And I don't recall specific examples. It was a very ineffective way for cross-examination, but ultimately successful. The board ruled in my client's favor on the incapacitation issue. What I think is more problematic in the cross-examination, or equally problematic in the cross-examination world, is not just the process. The process is very convoluted, difficult, and ineffective. But also that the cross-examination didn't take place in front of the ultimate trier of fact, because here Dr. Runn made the credibility decision, and I was never able to cross-examine the witness in front of Dr. Runn. And I would also point out, I was never able to cross-examine the investigator in this case. They didn't bring her to the hearing.
But they didn't allow you to compel her attendance.
There's no mechanism that I'm aware of
Yeah.
that I can compel her attendance, certainly not a
Am I right that I recall emails or letters in which you asked to have her there?
I recall asking to have her there. I don't recall a specific letter where I asked. They listed her in their list of witnesses that were to appear at the hearing. When that occurred, we didn't believe that we had to ask. And when we initially went to the first hearing, there were two hearings. One had to be rescheduled because one of the board members wasn't there for whatever reason. She was there. And then at the second hearing, she wasn't there. I don't know why.
Did you get to cross-examine her in any fashion at that time?
No, we didn't have the hearing because one of the board members was unavailable.
Did you make a proffer as to what you would have hoped to have obtained from her testimony or cross-examination?
We didn't make a proffer in the true sense of making a proffer as we would have in civil court, but what we did do is cross-examine her supervisor who was in attendance. The problem with that is she didn't have the foundation to ask a lot of questions. It wasn't an objection. She just didn't have the foundation. What did you say? What do you recall? All she could rely on was the report and at best conversations that she had with the investigator.
And what would you have hoped to obtain from her that you weren't able to obtain from her supervisor?
I would have examined her on the fundamental due process problem that we have in this case, which is they promised a fair and impartial investigation, and they never provided a fair and impartial investigation. In her first meeting with my client, she said, I am going to be fair and impartial, and I'm going to collect the evidence that we need in this case.
But as to the merits, as to the facts, especially the complainant's statements, there was nothing additional that you hoped to elicit from her that you weren't able to obtain?
Oh, no. There was a lot of information I would have hoped to obtain directly from her. Essentially, the Jane Roe came in and changed her story quite a bit. Her story was at times inconsistent with what the investigator said. So I would have asked her questions about that and how she does her investigation, how she keeps her notes.
So that was Miss Davis? Is that her name? What was it?
Tara Davis, that's correct, Your Honor.
What did she produce or do that came into evidence, was part of the record that the board and Mr. Runn considered?
She has an investigative report, and I have
Okay.
the citation of my...
Were her actual notes, there's some handwritten notes by her in our record, were those in evidence before the board?
I'm not sure which
The other
handwritten
ones
notes, specific ones that you're referring to. I can tell you that we were given access to her records, but we, as part of this convoluted process, we weren't able to copy her records.
Okay.
So they were either read to us, or we were able to look at them quickly and take notes.
Okay, our record contains 4 or 5 pages of kind of handwriting.
She has a lot of notes, Your Honor, and
But
there's video recordings that we weren't given access to.
Were those in evidence before the board? Do we even know that?
I don't know, Your Honor.
Okay.
If it's in the record, it's probably in evidence
Oh,
before the
no.
board, though, but I don't know. I would like to reserve the remainder of my time.
Good morning, Your Honors, and may it please the Court. Dan Dowd, along with my colleague Rebecca Van Dorn, on behalf of the appellee, the Arizona Board of Regents. In this case, Your Honor, substantial evidence establishes that the appellant perpetrated physical sexual acts against the complainant by force without consent and knowing that she didn't have the capacity to consent to sexual activity. For that reason, we ask that Dr. Runn's administrative decision be affirmed. Now, this morning, I'd like to try to touch on three things. First, very briefly review the policy and the standards that govern this appeal. Secondly, go to the substantial evidence that was available to Dr. Runn in making his decision, which presents an insurmountable hurdle to the appellant here. And then finally, and if necessary, address the belated and untimely due process attacks on the hearing and the investigation.
And we're especially concerned about the evidence, just to.
All right, well then
use that as a guide.
I've read your decisions. You know well the standard that governs this. In the absence of reweighing, and if there's room for two decisions, an administrative decision that accepts one is supported by substantial evidence. Substantial evidence by definition eliminates an arbitrary and capricious or abusive discretion standard. So then we go to the evidence. And it's interesting. It's very difficult for the appellant because he can't say, I've got better evidence, I've got more evidence, the scale tips in my favor. That doesn't work at this level. He has to negate it. He has to negate the evidence that was available to Dr. Runn that he relied upon in making the final administrative decision.
So she had consumed a lot of alcohol. She was drunk. That's undisputed. They had sex in a particular way for 20 to 25 minutes. That is undisputed. What evidence, other than the complainant's own statements, and we'll talk about them separately, but what other evidence supports the proposition that she was incapacitated within the meaning of the procedures, of the code of conduct?
Sure. So I'll take it chronologically. When she got there that night on April 2, 2016, and when she met appellant, the testimony is that the appellant took her into a back bedroom. This was before she was intoxicated. And she said, no, there will be no sex. That's corroborated by resident 2, who was a witness.
Now make that relevant, though.
Pardon me?
Earlier in the evening, she said
Yeah,
no sex.
Your Honor, I'm building to that, I promise. Okay. Resident 2 confirmed that he saw appellant and complainant go into a back bedroom for 5 minutes when the night started.
I think, wasn't his testimony actually they left, he wasn't sure where they went? He said that they left his line of sight. I thought there was at least some ambiguity about whether he said he actually saw them go into the bedroom.
Well, I know he told the police that they went into a back bedroom and it was for 5 minutes or less, which was consistent with her testimony. I got there, we went to the room, I said no, and we went back out. Okay. He observed her drink 7 to 8 shots of vodka in 90 minutes. He poured some of them.
Everyone's drunk.
Everyone's drunk. She says that she needs a wall.
Now, what other than her statements?
Okay.
What other evidence is there? That's what I'm struggling with, I'll tell you.
When she leaves the room, she finds girlfriend and they're leaving and they go outside. And girlfriend told the investigator, I tried to ask complainant why she was so upset and she wasn't able to answer coherently.
Okay.
Resident 2 says, as she left and was standing outside, let me make sure I get this right, she was crying, she needed help to stand, and she was really drunk. She testifies that during the incident itself, that when she finally appreciated what was going on, and we think it was from a combination of 3 things. 1, a tearing and burning sensation in her vaginal area. 2, a gagging sensation in her mouth. And 3, whatever flash emanated from the phone that participant used, that when she finally figured out that I'm having sex with these men, that she started crying and said, stop.
So she finally figured out she was having sex with these men because she saw a flash?
No, what she said was, when I finally realized what was happening, I had a burning sensation in my vaginal area. I had a gagging and burning sensation. Her words, and again, agree with Leonard, I apologize for the language, they were shoving penises into my mouth, and I had a burning, gagging sensation in the back of my throat. I was trying hard not to throw up. I was trying hard not to black out. I started crying and said, stop. They stop. Participant says that appellant at that point said, we better stop so we don't get in trouble. She testifies that appellant said, we better stop before she reports this.
So she it's not self-reported. I'm trying. she herself recognized that they had made that decision in a discussion in the room.
Well, I believe to fairly characterize what she said to the police, the investigator, and at the University Hearing Board hearing, is she said, I started crying and said, stop. At that point, appellant says one of two things, maybe both. We better stop before we get in trouble, or I don't want her to report us. That's when she gathers herself, leaves the room, finds girlfriend, stumbles outside, and we have the girlfriend's testimony as to what she observed and resident two's testimony as to what he observed.
Thank you.
So that's evidence that was available to Dr. Rund that he looked at. In his 2 letters articulating his decision on the basis of incapacitation, he details what he looked at. And he said, these are his words, I don't find it plausible that the complainant, who earlier in the night told appellant, I'm not going to have sex with you alone, would later, and without explanation, not only have sex with appellant, but with a near stranger participant who she met that night.
What if she
What
was
do
The
you
only
mean
thing that
without
changed was
explanation?
7 shots of vodka.
What do you mean without explanation?
Well, that was his words, without explanation, that the only reason he could find based on this record that would support that conduct occurring later in the evening, given what had happened earlier in the evening, and I think his words were the only variable were 7 to 8 shots of vodka.
Well, there was
So
also hours of dancing and apparently some types of interactions between the 3 of them.
And I think it
In
was,
a group that I think all the witnesses said that they saw them interacting.
that's true. And Dr. Rund,
So she could have, did she have to provide an explanation for wanting to change her mind?
well, I think you have to square that with what happened in the bedroom. He says, I can't square 2 things. I can't square the appellant saying she's a 3 on the scale of 10. She's a 110-pound freshman who had 7 to 8 shots of vodka. And I also can't square that if she was a willing participant, to use the word of their brief, uninhibited, why in the middle of the sexual activity she would abruptly call it to a halt, start crying, and leave the room.
Because she realized she was being videotaped. Could
she
have
was
been
hurting.
the basis for that.
Or
She made a decision.
that's possible, but it's equally possible that she finally came to, realized what was going on, maybe from the flash of the cell phone, maybe not, maybe from the fact that she was suffering vaginal tears, maybe from the burning sensation in the back of her throat, and she said, I'm not going to do this. And she left. And he couldn't square that. So your question was why without explanation? He couldn't square the notion that this was uninhibited sexual activity by a willing participant, given that sequence of events.
Well,
And a
isn't-
reasonable mind could accept that to reach his conclusion.
Go back a couple of paragraphs where you're
Sure.
talking about going to the bedroom, no, I don't want to have sex with you, and why her decision hours later to have a threesome, or the fact that she had engaged in a threesome. Rund concluded that the only explanation for that was that she was incapacitated. Why wasn't it just that she was impaired? Why do you need to leap from having a lot to drink and becoming impaired to unable to make a judgment on your own?
And of course, Your Honor, that's a fine line. When does intoxication become incapacitation? And the only thing we can fall back on is the definition in the Student Code of Conduct, which says evidence of an inability to make a rational and informed judgment, often caused by alcohol consumption. They're not mutually exclusive. Intoxication can certainly lead to incapacitation. One can be both.
But
One can be intoxicated and incapacitated.
Didn't Rund improperly conclude that a threesome was by definition irrational?
I don't think that's a fair reading of his letter. He found the conduct to be outrageous, but if you read what got him to the adjective outrageous, it was his description that the evening started with a, no, there'll be no sex. It ended after 7 shots of vodka with a man she'd never even met, and the appellant in a room simultaneously engaging in different sex acts with her, where she cuts it off and says, that's enough. I think the fair reading of that, it's not an imposition of his sexual mores. There's no evidence to support that. It was him saying, this is an outrageous sequence of events.
He said it was outrageous, and
But he didn't
that's,
say
that's
this.
some element of his sexual
But he
mores.
didn't say a threesome was outrageous, and I think that's the way it's being construed by appellant. He's saying this sequence of events was outrageous. But if you strip away the adjective from his letter, and it appears once in one of the 2 letters, and you look at the evidence, what we're doing here is we're lining up the appellant's evidence and the complainant or the university's evidence, and we're seeing which way it tips. And we can't do that here. Dr. Rund did that.
Talk to me about incapacitation, because I struggled with the definition, because incapacitated at its base seems to be blackout. I mean, you'd think that inability to stand, do anything, function, that's when you're incapacitated. But the definition seems to be broader than that, but falls short of impairment. So the definition, at least if you read the other things that are described in it, the inability to make decisions, that certainly is less than incapacitated, or it seems to be anyway.
Well, I think
What exactly is the standard of review? Would you agree that it's more than impairment?
I would agree that it can be more than intoxication or impairment, but they're not mutually exclusive. It's an assessment by the fact finder based upon the evidence presented as, was this person able to make a rational and informed judgment? And the impairment can come physically. I mean, hypothetically, somebody could be held down. They're incapacitated. It can come mentally. It can come from drugs. It could come from a head injury. It can come from drinking. But they're not mutually exclusive. And I know the argument is that Rund conflated intoxication with incapacitation as if they're two separate streets. They're not.
Counselor, are we picking and choosing what incapacitation and unable to make informed decisions caused here? Are we? I guess I'm having trouble with the notion that there's a flash that goes off and she says, "Hey, what's going on?" Fair? And I'm not trying to misquote anybody. She said, "What's going on? You're taking pictures." And they said, "No, we're not." She said, "Yes, you are. Stop." And they stopped. Is she incapacitated and unable to make an informed decision at that point?
You know, it's probably a closer call, but that's not the relevant point. The relevant point is when the sexual activity was ongoing, and that preceded the stop.
I may be confused. It wasn't the sexual activity that they were taking pictures of?
Well, all we have is a still photo of one that shows her laying on the bed unclothed. That's all that's in the record. But I think the point, Your Honor, is that it's not an on-off button here. It's not a
Exactly. It's not.
But so you have what does any fact finder do? They look at all of the evidence and they say, okay, based on this evidence, and the standard is more probably than not, is it more probable than not that this complainant in this situation was able to make a rational and informed judgment about participating in consensual sexual activity with a man she told no to an hour and a half earlier and a man she'd never met?
What about? Go ahead.
The complainant offered expert testimony by a former prosecutor, very experienced prosecutor, who, as I understand her testimony, said, you don't do what is undisputedly she did, what's undisputed that she did for 20 to 25 minutes. That's a physically strenuous exercise. You can't do that if you're incapacitated. Is there any authority, other cases, definitions, to support the proposition that you can possibly be mentally incapacitated such that you can't say no, but you can engage in quite a strenuous physical activity for such a long period of time?
You know, I'm not aware if there's medical authority.
I just don't get it. I'm having a hard time rationalizing that.
Well, I think, again, we have to look at the continuum. We also have the nurse who did the SANE exam who said that these injuries are consistent with the complainant's description of what happened that night.
Well,
and we have the police
they're
saying
consistent with bruises on her knees, which is what happens if you do that for 20 to 25 minutes.
Right. And so then what we have is the complainant saying repeatedly, I didn't consent, I didn't want to have sex. By the time we went into that room, I had to lean up against a wall. I was so drunk. And then let's look at what we have the appellant saying, okay? We have the appellant saying she's a 3 on a scale of 10. That's what she said. That's what he said as part of this process. But what did he say the day after the event?
You know what? I'm not even focusing on what he said.
But it's circumstantial evidence of her incapacitation.
Okay.
So the next day, they have the confrontation call, okay? And this is less than a day after 2 men were simultaneously penetrating her body. And she asked him, was there anybody else in there? And he says, no. And she presses him. I might be going crazy. I seem to remember that there was somebody else in there. And he says, no. He says it 7 times, okay? 7 times. So this is a guy who's going to stand up here and say a couple things. One, the argument in the brief is there is no evidence of incapacitation in that bedroom. And 2, there is no evidence that this appellant knew that she was incapacitated. Yet less than 24 hours after the incident, he believes that she was so out of it that he could lie to her about the fact that a man she had just met was penetrating her body.
Could that be because she asked as opposed to stating it? I mean,
But
he might not have thought that she was that drunk at the time, but when someone called me the next day and says, I don't remember what happens, you might change your opinion at that point about how drunk they were.
Well, except she put that question to him. Why did you think, this is a quote, why did you think it was okay for you to have sex with me when I was so drunk, literally? And his answer isn't, boy, I'm sorry. I thought you were a willing participant. I misread the signals. I apologize. No, what he said was, I was super drunk. And then he goes on to say, he asks himself while she's on the phone, why did I do it while you were so drunk? Well, I was really drunk too. And that's what happens when 2 drunk people hang out. We were both drunk, and this just happened. So this is coming from the same appellant who will stand here and say there was no evidence that she was intoxicated.
But you said earlier that incapacitation is not necessarily the same as intoxication. So the fact she was drunk, tell me what that does, because I'm not following.
Well, look, you can be intoxicated and incapacitated. Intoxication is certainly one of the causes of incapacitation. It says that in the rule.
Right.
But if you step back and just apply the smell test to this, to think that you thought you could get away with a lie to a woman about the fact that a stranger was having sex with her the night before is certainly evidence from which Dr. Rund could have concluded, wait a minute, he knew she was incapacitated too. Who could think they could get away with that sort of an outlandish statement unless
counsel.
you thought that she was incapacitated?
Counsel, you're talking about, you're drawing these lines about what she could have or she couldn't have, or we've talked about this loosely, but at some point, the one person asks if she would allow the other person to ejaculate inside of her, correct?
Correct.
Of the 2 guys that were there. So the one guy says, can he ejaculate inside you? And she says, no. That's a values decision, right?
Well, it's an utterance that comes at that moment.
So which utterances are we going to go with?
We can go with all of them because that's what Dr. Rund had in front of him. Every single one of them. Let's put them all out there.
So she
and then you
clearly
have to
knew
decide.
she clearly knew there were 2 other people in the bedroom.
Right.
Okay.
No, the next day on the confrontation call, she asked that. She knew the answer. She asked it to see what he would say. That was the police were sitting right with her when she had the call. So she's not saying that she didn't know.
So she
there were
wasn't
2
so
men.
incapacitated that she didn't know what was going on.
When she came to. I mean, she says, I was physically unable to resist, and when I realized what was going on, I said, stop.
But the
So-
night when it was going on, so when you say when she woke up or whatever it was you said, sobered up, I mean, I don't even know what your term was there, I don't remember. But in the middle of that, in the course of that, she was asked if number 2 person could do a thing, and she, in the middle of this going down, she says, no, he cannot do that, I will not allow it. And they stopped doing it. If that's not happened,
It's close.
Help
It-
clear me.
It was at the end, and appellant said, can he finish, referring to participant, and she said no, and then she left. But
So she was already up and dressed and on her way out.
well, no, I mean, she said no, gathered her clothes and left, is what the evidence in the record is. But that's suggesting that unless you're incapacitated from start to finish, you're not incapacitated at all. And that's
So-
not the standard.
So Mr. Rund must have concluded that she was incapacitated at the beginning, but not at the end.
Well, I don't think he had a scalpel that did it that fine. He said that looking at the amalgam of evidence, the body of evidence here, I find, I'm putting the language in the words of the standard that applies, that more likely than not, he violated the sexual misconduct provision by having sex with an incapacitated and unwilling participant. I see that I've run out of time. Thank you. We'd ask that you affirm the decision.
Thank you.
Your Honors, no one has ever testified that she was incapacitated, no third party. Her girlfriend never came to the hearing and testified that she was incapacitated. She never testified in her statements to the police that she was incapacitated. She said she was drunk. She never said she was incapacitated. The people at the party, no one testified that she was incapacitated or had any manifestations of incapacitation, such as falling down or needing to stand up on a wall. The board was unable to find incapacitation after judging credibility and looking at all the evidence. When we talk about additional evidence, understand there's a video of this incident, and ASU didn't collect it. That's not a fair and impartial investigation. They had the ability to require the accuser to obtain that video. They never even attempted to have her obtain that video, and she even said that she would. They never asked her to obtain it.
I want to interrupt you for just a second.
Yes, Your Honor.
What does our record show as far as the four things you pointed out, or let's say the three things, because the fourth one is, I think, the giving blowjobs, which would have been the entire time. Can't believe I just said that word, or those two words on the record. But the first three things, the video being videotaped, no stop, the sex started hurting, no stop, do not ejaculate. What does our record show as to how long in this 20-minute event, how long into this 20-minute event did those events occur?
Towards the end, Your Honor, based on the testimony, except for the fact of being on your knees and physically being able to support yourself.
I understand that one. So would you agree, and maybe you wouldn't, that it's possible that someone could be incapacitated at the beginning of this event and at some point had moments which she sobered up and fell out of incapacitation, and that would mean your client, for at least the first 15 minutes or 10 minutes or however long it was having sex with someone without their consent?
I think everything's possible. I think it would be inconsistent with her testimony, because what she said, and before she went into the room, and as she passed her girlfriend and going into the room, there's pictures. We have pictures in the record. We have everyone in the party seeing her. This isn't a long period of time. So 5 minutes before she's out dancing, having fun, taking pictures in a party, she goes into the room. She's now incapacitated. She claims she was more incapacitated when she left. And when she left the room, she was more incapacitated, so not less. Is it possible? Sure. Is it consistent with her testimony? No. It is not consistent with her acts at the time of sex, and the only evidence that we have at the time of sex. I see that my time's done. I don't know how you win this case, Your Honors. She's always going to have a version of the stories. We refuted everything. We rely on her version of the stories. She admits the fundamental defense. We went to the finder of fact, and they ruled in my client's favor. We ask that you reverse and remand.
Thank you, folks, for the oral argument today. We're going to take it under advisement at this time. We will rule in due course. We're adjourned.